Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We interviewed Randy Saunders, partner at Nelson Mullins. Although Randy is based in Huntington, West Virginia, Nelson Mullins has offices all over the country and is one of the few firms with multi-state coverage focusing solely on tax lien and tax deed processes. We invited Randy to come back and talk about Kentucky, but this time he's focusing on what happens after the sale in the foreclosure process. So it's time to sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Everybody, welcome back to Tax Sale Insiders. I am, your host, Brian Seidensticker with Tax Sale Resources, and with us again, luckily today, I have Randy Saunders, who gave us an excellent overview of the tax sale process in Kentucky on another episode. We fell short on time on that one, so we're gonna, kind of pick up where we left off and talk about the foreclosure process here. But before we do that, Randy, welcome. Thanks again for joining us.
Yeah, thanks for having me. I appreciate it. I really enjoy doing these and getting to spend a little time talking through this stuff with you. So look forward to it. And, last time we really went through just the acquisition phase. Talked about how Kentucky is a tax lien state. I think a couple of important things to remember is the requirement to, set up a payment plan, that you do have that 1 year tolling period. So when you acquire the tax lien at the sale, you basically can't take any action until the following year. And so one of the other things we talked about was the fact that because there is such a long period, it's 10 years plus one, essentially, that those tax liens are good for. You can have those liens stacked up over years. So you could always go back and try to acquire a previous lien if you wanted to move forward a little bit more quickly. But I think if they go back and the viewers kind of look at the difference between West Virginia and Kentucky, because those are the two most recent ones we discussed, West Virginia offers an opportunity to try to have a plan to acquire land. And I think Kentucky is kind of the exact opposite. It offers you an opportunity to acquire a portfolio that you are getting redemption and interest rate on. Also allows you to set up a servicing portfolio that you can, charge some additional servicing fees on. So I think it's one of the biggest things as you go into it is, understanding the different components and what you ultimately want. And I think we're getting ready to today to talk about, what happens when we get past the third payment plan, or what happens when we're sitting on, a portfolio of 200 liens that are between 4 and 6 years old. What are we going to do with these? And so I think this brings us to that place where Kentucky poses a challenge, because as we talked about last time, Kentucky has 120 counties. From Paducah to Ashland, you're talking about a 6 or more hour drive, maybe 7 hours. And so that's a lot of ground to cover. And it's a couple hours from northern Kentucky where you're at in Cincinnati, going down to, say, Franklin Simpson on the Kentucky-Tennessee border. So you got a lot of ground to cover, a lot of small counties. You're dealing with a lot of judicial systems, a lot of judges, and a lot of master commissioners. So when you jump into the state, there are statutory, attorney's fees that are allowed, that you can, get feedback on. But as you set all of this up, I think you're looking at how many attorneys am I going to have, how many court systems do I want to deal with, and how many of these fires do I want to have going at once, for lack of a better word. Because if you go in and you spend a lot of capital, and instead of focusing that capital on certain areas and you divide it across 120 counties, you're going to be stretched pretty thin. You're going to have, a lot of the servicing responsibility. You're going to have a lot of things tied up in court, and you're going to have a lot of issues because the thing too that you have is that there's once it goes to the master commissioner, and we'll talk about that, again, you're at the mercy of the judicial system, and attorneys will tell you this is what it traditionally takes, but we all know sometimes in rare instances, it goes faster.
Mhm.
Most of the time it goes longer. And so, you're going to get in a position where you're thinking, hey, we're on an 8-month cycle, and all of a sudden you're at 16 months, 18 months, and then you're waiting on the master commissioner to put these to sale. So I can jump in. I don't know if you had any specific questions just as we transition here, or if you want me just to kind of jump into the pre-foreclosure process and then what the folks can expect.
Yeah, it's real quick. So for anybody that's joining us for the first time and you didn't watch Randy's previous interview on Kentucky, we did one on West Virginia, but interview on Kentucky, and you have questions on the process from acquisition through servicing up to where we're going to start today, please refer back to that other episode. So with that, I guess, Randy, let's just kind of start it like you had said. You have to wait at least a year. You can wait to 10 years, or it ends up being 11 years, right?
Right.
At some point in the middle there, you've got to do something, right? And so why don't we just start with, assuming that something needs to be done, at that 4 to 6 year range, and what are the options to the investor at that point, and then maybe we'll dig down into each one of those options in more detail.
And what I'll say is sometimes today you may see me looking down, and this is something that Brian has. I think it's published on the site still. I think it's still, for your subscribers, it's still available. This is the updated comprehensive guide to understand Kentucky tax sales. And so a lot of what I'm going to be talking about today can be found in there, some to greater detail. And as always, if you have any questions, you can reach out to Brian, reach out to me directly. Brian knows how to get in touch with us. But what I'll start with is what you just talked about. Anytime after the expiration of the 1-year tolling period, but before 11 years following the date of the taxpayer's delinquency, the purchaser has to institute a foreclosure action. If not, just like any other type of lien, but a lot of, we're I guess in my field, there are a lot of liens, they have a lifespan. And if you don't enforce that lien during that lifespan, then it's extinguished. And so it may still be showing there, but you can't enforce it. It's just like with other forms of debt collection. Once you're past the statutory period, it's bad debt, you can't collect. So Kentucky has a 1-year tolling period. And what that is, the purchaser can't bring an action to collect amounts due until 1 year from the date, not of the purchase, but 1 year from the date that the taxes became delinquent. And so taxes are considered delinquent on January 1st of each year. So a lawsuit can't be commenced until January 1st of the following year. So I think it's important to know that. And again, Kentucky is not a state where expediency or urgency is a factor. But if you are in a position where you want to try to move these as quickly as possible, your date isn't dictated by the date that you purchase. Your date's dictated by the date that the taxpayer became delinquent. And for that whole portfolio that you purchase in that year, it's all going to be that January 1 deadline. So for this year, it's all January 1, 2021. So any tax lien then you couldn't move to enforce until January 1 of 2022. So what I think that the biggest step, we talked last time about a 50-day letter, that you have to send a letter out 50 days after acquiring and providing specific information. And so now this time the purchaser has to send out to the taxpayer by first-class mail, and you have to have proof of mailing. Again, this is important because at this point, what you're doing now is you're setting up your litigation. And if you don't have counsel or you don't have those servicing guidelines set in place down the road, this is going to potentially cause you some problems if you cannot produce this stuff easily. Because the judge, he's going to be up there. He's going to have some familiarity with this. He's going to be looking through the file. He wants to see a checklist of certain things. And the easier that you can make it for him goes back to that that hope springs eternal, that maybe our case will go faster than all the others. So if we have it and we're ready to go, we can go. So the notice has to inform the taxpayer that an enforcement action is going to take place. So basically, what I tell them, look, we've got this. You've already had communications with this taxpayer, because we've already talked about the fact that there has to be a payment plan in place. Mm-hmm. So something's happened at this point. The payment plan's fallen through. Whatever it is that's transpired, it's gotten you to the point where now we're going to take this foreclosure action. So you've got to tell them. To send notice, the purchaser has to obtain the most recent address for the property owner from the PVA. Each county has a PVA. It's the property value administrator in the county. And again, that's important, because they're going to go back and they're going to look. You may have an address. The tax ticket may have an address. But what happened before you send that 45-day letter, you need to go and be able to show, here's what I got from the PVA. And again, show that to the judge. Very easy. I sent it to him. I did what I was supposed to do. There's no dispute there. And so you don't have to send notice to any other party other than the owner of record as provided by the PVA. And I'm not saying you don't have to send notice at all. I'm just saying the only PVA address that you have to get is for the owner. The other thing that sometimes slips past folks is what happens if it gets returned undelivered, or what happens if the return receipt isn't signed. And so within 20 days of receiving notice that it was returned undeliverable, the notice has to be resent by first-class mail. Again, you have to have proof of mailing, and it has to be mailed to the occupant so that it's delivered. And so then what this means is you want to be able to go in court at that time, and you want to be able to tell the judge, once we're not there yet, but once we file our action, we want to be able to go in court. We want to be able to say, Judge, here's my 45-day limit. And Judge, here's where, proof that I mailed it. And then here is, proof that I got that address from the PVA. And when it was returned undeliverable, here's where I sent it again. In that circumstance, it's because a lot of times you got 120 counties, as we talked about, 120 judges. You may have a sympathetic judge. You may have a judge that's by the book. But those are the things you can control. And if you're controlling them, regardless of what type of atmosphere might exist, you're putting it in the record and making it very difficult for them to try to find any strict statutory construction argument that you didn't follow. If you can't come in with that, if you can't come into court and show that, or you said, here's my 45-day letter, and the judge is like, okay, well show me where it was mailed first class, or show me where and you can't do that, that's not going to be good enough. And you're going to get into a position where you're putting yourself again at the back of the timetable.
Does it okay, so maybe that answers my question, is by not doing those things, I'll say perfectly, right? Didn't send it for first class, or didn't send it in 25 days versus 20 on the follow-up. Do all those things basically make the enforcement null and void, as in like you have worthless paper, or is it, like you said, reset the clock, you got to start over? It is a pain, but it's not a catastrophic situation.
Yeah, it's not worthless paper, but it's going to be, when you look at the statute's KRS 134-490, and a lot of courts that you get into across a lot of jurisdictions are going to want to require strict compliance, regardless if that's the letter of the law. Because ultimately, just like going back to where I sat in West Virginia, our judges are elected. So I go to some county and I'm representing an out-of-state business against John Smith. The judge is going to want to be fair to those folks, and he's going to want to say, you can't prove to me that you sent this letter to him, and he's telling me he didn't get it. You are the one that's doing this. You're the one that's sending out 500 of these. You should be able to show me that you sent this out, that it was either received or it wasn't received, and if it wasn't received, that you followed the statutory process. And so what we see a lot of times in all the states that we're in is that if you don't adhere to that strict compliance, across the board, you are opening yourself up to problems in pushing it forward. Now, what I'll say is that doesn't, like you said, it doesn't render the paper null and void. But if you didn't comply with that, then you're going to have issues. You're going to have to either undertake in that litigation, depending on what the issue is, to try to resolve it, or perhaps go back and start over. And again, then you've got statutory attorney's fees that you're entitled to. Under the statute, you can ask for more. But again, that's up to the judicial discretion. And if the reason you're asking for more is because the judge says you didn't follow the statute, probably not going to let you get more. But so when the notice of institution of action is sent out, it has to include these things. And I've got a list just so because I wanted to give the listener an idea of how specific and kind of how detailed this has to be, and why it's a good idea to make sure you're partnering with somebody who's at least helping you put this together, so that your letter, at least, you may have a database where you can pull over the information and populate the letter, but make sure you've got everything in there.
Yeah.
So you have to have a statement that the certificate of delinquency is a lien of record against the property evidenced by the certificate of delinquency. You have to have a statement that the certificate bears interest at a rate of 12% per annum. You have to have a statement that if the certificate is not paid, it will be subject to collection as provided by law, and that the collection actions may include foreclosure. You have to include a complete listing of the amount due as of the date of the notice. Again, so that's going to be a recalculating of how much is due, and that takes some work. And again, that's why when you're coming to Kentucky, you want to make sure you have these systems in place. And again, they're not onerous, or they're not insurmountable, but they're also not. I mean, I think it's administrative, and you got to make sure that you have that in place. It has to be broken down as following. You have to be able to provide the purchase price of the certificate. You have to provide the interest that's accrued after the purchase of the certificate, and any and all fees that are going to be imposed by the third party. And again, that's what it sets out. And quite frankly, if they get counsel, or if they want to contest and come back and say you're not entitled to these fees, so there's no statutory entitlement to this. So they want a full accounting of what they're going to be charged. For purchases required to register with the department, and we talked about that last time. How much are you purchasing, and are you, because in Kentucky there's the Department of Revenue, and then there's each county, and so you've got to register with the Department of Revenue, and then you've also need to communicate with each county and determine what you need to do to be a purchaser of tax liens in that county. But due to the volume of purchases, and for certificates purchased after 2012, a statement informing the taxpayer that upon written request and payment of a processing fee, the purchaser will offer a payment plan and information detailing the provisions of law relating to third-party purchaser fees and charges. So again, you're reminding them of stuff that you've already dealt with. You're doing, and providing kind of a full accounting of all this information, and that's all statutorily, required. Now, if we want to take a step back, because one of the things again in there is reminding the taxpayer again that you are going to, or that you're required to do a payment plan. Well, and we did talk about this a little bit last time, but I want to go back into this again, because this is that period, where you talked about after 1 year, but before the 11 years. So it says, persons or entities that pay or intend to pay more than for more than 5 certificates of delinquency statewide, which that's not a lot, or more than 3 in any county, or intend to invest more than $10,000 in payment of certificates statewide in any calendar year, must provide a monthly installment plan to a taxpayer. So essentially, I would assume anybody listening to this broadcast is going to be somebody that's going to have that set up. So again, keep that, and that's not really, I think you can go back and listen to last time when we talked a lot about that, but just make sure you've got that in place. And that's what we talked about. For each installment plan, you can add $8. Again, if you've got a portfolio of 10, that's not going to make you a lot of money. If you got a portfolio of 100, or 1,000, then that could add and help with the offset the cost of that administrative component.
Right. So we
Go ahead. Yes.
I was going to say, so this notification, right, that needs to go out to the address on record through the PVA and followed up with, and then obviously that's very critical later in the step. After we've sent that notice, I guess, help me understand the process from that point forward.
So, and again, that is just, let me go back. So you are sending that out at least 45 days before. So you could send it out before that, but if you're going to file an action in the circuit court, and again, we'll talk about this, the foreclosure action has to be initiated in the circuit court, and they have to be initiated in the county where the property is located. So again, if you think, hey, I'll come in, I'll buy all 120 counties, I'll spend a couple $1 million, and then I'll just file all my actions, say in Lexington and Fayette County, or in Louisville and Jefferson County. And I think that's consistent with almost every state. But again, you're going to have to go to all those different counties, and that's why it's problematic in Kentucky. Not problematic, but it's a logistical issue that you have to consider and deal with, before you decide to buy across the state. I'd say I would employ a strategy where maybe you do it by thirds. You start in the middle, maybe go to Eastern or Western, you kind of deploy it over a 3-year time period as you start to move forward. But so what you're doing here is you're just sending that 45-day, it's kind of like that last letter that's going out saying, all right, here it is. And once that letter goes out 45 days after, then you can file the action. The only time that time frame gets a little hairy is if say you acquire a portfolio, and in that portfolio you've got a certain number of certificates that are like 8, 9, 10 years old. So you're running up against that back end. And so there, what you want to do is you want to make sure that you get that letter out between 45 days and whenever your statutory limit runs. Does that make sense?
Yeah.
I'm not sure if I'm articulating that. Just because otherwise, you can file at any time and wait 45 days and file. You've got basically that 10-year period after the 1-year period of tolling. So the only time you're going to run into a door that closes if you're waiting until the 11th hour or the 11th year and trying to send out that 45-day letter, because you can't, basically the action's not going to be able to accrue until after that 45 days runs that you send it. So, but that's really the only time I've ever seen that be an issue. And it's not uncommon, when you acquire a portfolio, because there's probably going to be some older certs that are left, lying around. Does that answer?
Yeah. So a couple key things there, right? One's making sure you wait at least the 45 days, but you can wait longer, and don't wait until the last day of your 11 years, right? You need to have done it well in advance of that, because you're up against that closed door at that point. So when you start that action after that, at least 45 days, is it a standard foreclosure at that point? And if so, let's maybe do a quick overview of what that looks like.
Yeah, I wouldn't call it a standard foreclosure. You're filing an action in the circuit court to foreclose on that tax lien cert, and then you're going to have to get service on everybody, which that is sometimes difficult and tricky and takes time. You're going to have to do your title search, make sure you've got everybody. The other thing is, at that point, especially if you've got an age cert, or you've got a cert that's not aged but that hasn't paid, you've got somebody that's been delinquent for multiple years, because then you're going to have other parties that are going to be lining up to get their slot. And here it's pro rata distribution, so it's not as much of a concern about well, if I have a lien that's 8 years old, you have a lien that's 4 years old, and somebody else has a lien that's 2 years old, is that going to line up like priority in a mortgage context?
Mhm.
It's not. You're basically all going to go in, you're going to get pro rata distribution. So whatever it sells for, after it goes through the process, then the master commissioner gets paid off, you guys will get paid off. And then if there's something left over, it would go to any other liens or judgments that were out there, and then to the tax benefit themselves. So it kind of just flows down that waterfall like you'd expect. But I think, for the most part, what you're going to see is a lot of uncontested actions, and a lot of pro se actions. And sometimes you think, oh, pro se, that's good. They don't even have an attorney. That's going to be easy, right? No. Usually if it's pro se, it takes 3 times as long, simply, again, because of the practical factor. These are folks that don't have any, real experience in the courtroom or with the legal process. And rightfully so, just like if it was us or our family member, when they come in before the judge is going to be a little, probably more lenient and explain the process a little bit and give them a few more chances to try to figure it out or to get an attorney. But let's say, okay, we get service on everybody, we filed the action, we've provided all the documentation, it's clear. At that point, there's going to be an order, and that order is going to go out to the master commissioner for sale.
Okay.
But the master commissioner also, there's other components to go in there. The master commissioner is going to have the property appraised, and he's going to set the time for the foreclosure sale and do all those things. But, I think I think most of the folks that again are listening to this generally understand how that process goes through. I think the landmines maybe in Kentucky, are 120 different counties that you're dealing with. The prospect of pro se, making sure that when you come into court, you have your documents in place so that you can hand it to the judge and say everything was done correctly. You've got the component of not being able to control the time or the decisions, obviously, that the judge is going to make. If the judge wants to give the delinquent taxpayer more time, they're going to, and that's outside of our control. It's outside of the client's control. Once it gets to that point, then it dumps to the master commissioner. And again, you're in a process where you don't have any ability, and there's no time frame or no specification that says the master commissioner has to set this for sale within 60 days. That's not going to happen. It's going to go to the master commissioner, and we've had some that go quickly, and we've had some that take months and months and months to get set and to get sold. So, again, when you're looking at it and you're trying to figure out, I've got this, when do I make the decision that I want to push it? And I think part of that is the payment plan aspect of it. Are you going to be able to go into court and say, I've given this individual 2 or 3 payment plans too, they keep failing on it, they don't call me back, we're not having communication, those types of things from a practical standpoint, I think help you too and move it through a little bit faster. But almost by default, the process of filing, trying to serve everybody, which always takes a long time, getting it to decision in front of the judge, getting it moved to the master commissioner, getting it moved to sale, all those things then weigh against, should we try a payment plan one more time? Does that make sense?
Yeah.
So and the court's going to say, look, you got 10 years to bring this, why don't you? Because they're going to come in and they're going to say, oh, if I just had a little bit more time, if we could just do one more payment plan, and then maybe you're back there and you're trying to payment plan again. So you've got to, I think, have a consistent.
It's not like that starts the clock all over. You do a payment plan, and then a year down the road, it doesn't work out. You can't just pick up where you left off. You got to start the process all over.
Yeah, unless you could move to stay potentially and stay for. There are ways that we could try to talk, like say, okay, would be willing to do a payment plan. Let's try to get all this paid off. If she can do a payment plan and get it paid off over the next 5 months, 6 months, something like that, ask them to stay. But again, that's at the court's discretion.
Okay.
So, but I think it's just having those kind of internal procedures that say, this is how we're going to do it. And we're going to have, if they come to us for a payment plan, they pay it off. Maybe we'll give a little bit of a discount, as an enticement to get it done. If we reach X time period, we're going to move to foreclose. And then you've got a little bit of flexibility in there, but I think you're just moving it that way all along. Because I think the other thing that, from an administrative perspective, it seems real difficult to me to try to come up with a new policies and procedures for every single cert that you have. I think you got to have a game plan in place saying,
Right.
This is how we're going to go, but then also have some flexibility if you've got a unique circumstance. Like we talked about last time, you don't want to be the person in the newspaper that foreclosed on the vet who, the veteran who had an 86-cent, tax delinquency.
Right. As opposed to the, vacant house on the corner that everybody would love to see, brought back.
The meth is cooking in the bathtub and they want it, or whatever it might be.
So, so as far as the action itself, it's a judicial action, right? So, got three questions that come out of the master commissioner sale. One, the deed that's sold, right, ends up being insurable. Is that accurate? You don't have to do a separate quiet title action after that deed is sold.
Yeah. So the master commissioner conveys the property, and I believe I'm trying to look here to see if I've got in my notes what type of a deed is conveyed. But at that point, give me just one sec here. But yes, I believe that is accurate. The master commissioner's deed after the foreclosure sale would be insurable just like any other foreclosure sale.
Now, what happens to the properties that go to the master commissioner sale and they end up not being purchased by anybody? Do those go back to the lien holder, or what happens in that situation?
No, so if there's no purchaser at the foreclosure sale, the master commissioner then issues a deed to the owner of the certificate of delinquency, and that person has a pro rata interest per the amount of the certificate.
Okay.
And so because, and you think about why would that be? Because what if you've got 6 people that have certs? So again, just like pro rata distribution of the funds,
Right.
Post sale, you have a pro rata share, which again, that's why Kentucky's probably not the state for you if you're looking to acquire property, because then what are you going to, then you're in a position where you're looking at filing action for judicial partition.
So it's pro rata based on your percent of the total outstanding taxes.
Yes.
Okay. So
based on the amount of your certificate.
So just for round numbers, if there were $5,000 in open taxes that started the whole process through the master commissioner sale, and your particular lien was only 1,000 of that, at the end of the day, you'd end up with 20% interest in that property, and all the 4 other lien holders would end up with 20%. So it's pretty key. Correct me if I'm wrong here, but it's pretty key when you get to that point and you do, pursue with an action. Either it's a property that is fairly confident it's going to sell, or you want to do something to have all of the liens that are outstanding, right? So
and we can do that, and we do that a lot, and quite frankly, if you do that early in the process, or because sometimes you can anticipate and you can look and you can say it's might not go, and so then all of these certs are freely assignable at the time that they're purchased. So you could go, in this case, when you're bringing an action, you could go to the other certificate holders and purchase their certificates, and basically like you said, if there's the other 4, go and purchase those and bring it all back together. Like what's the Avengers movie where you got the Infinity Gauntlet? You bring it all back together so that you have all of the components. But they're I guess it just depends too, in understanding who else would be involved, what their ultimate goal is. Heck, for them, it might be an opportunity to get paid and get the money, and they basically look at it as a redemption.
Okay.
So
you mentioned this, and just to make it clear, you can buy or sell those liens even after that action is filed. It's not like they're frozen and you'd have to start over for any reason. You can still transact or assign those liens back and forth right up until the point where the master commissioner sale is complete. Correct?
Yeah. You can do that at any time.
Interesting. Okay. Is there any, I mean, it sounds like if you're really truly after property, right, you can forego the lien purchasing and attend the master commissioner sales, right? If you want to buy it. Is there any like statute minimum of where that bid starts? Is it basically all open taxes with interest and other fees, or is it a set at a percentage of assessed value?
So, and I will tell you this, let me look here, because I don't know that in Kentucky I've actually ever attended one of the master commissioner sales. And so, let me look through here. I mean, what I would say is, I know, the master commissioner is going to appraise the property, and he's gonna set up the foreclosure sale. You as the purchaser and any other, because a lot of times when you look at the traditional foreclosure, like in the mortgage industry, if you have an interest in the property, you can't show up and bid on your own property, right? But if you're a tax lien investor, you can show up and you can bid. If you're the high bidder, again, you end up the owner of the property. But
that's almost a strategy.
It says if it doesn't bring 2/3 of its appraised value, and I think this is where. So again, I think this is the component that's more important. I don't know, and honestly, where they start the bidding at. But if it doesn't bring 2/3 value of its appraised value that the master commissioner appraised it for, the taxpayer and/or their representatives can redeem the property within 6 months from the day of the sale. To redeem the property, the taxpayer has to pay the original purchase money, 10% or 10% per year interest, and any reasonable costs incurred by the purchaser after the sale for maintenance or repair, utility expenses, insurance, association fees, or taxes. So I think that's kind of what you were getting at is there, when you look at a threshold, I don't know, again, off the top of my head, if there's a starting threshold for the bid. I would assume that would be set by the master commissioner. It probably varies by county, but statutorily across the board, and this is under KRS 462-350. And it says that you've got the master commissioner's appraisal. If you don't bring 2/3 value at the sale, then you create that secondary redemption opportunity for the delinquent taxpayer.
Interesting. Okay. Learn something every day in this industry, Matt.
Well, and it's just more uncertainty though, too, and that's why it's like, I always feel like, and I think Kentucky and West Virginia both, and I'm sure this is probably common in a lot of places, but it seems like the further out west you get, the land hasn't always been in the family as long. In West Virginia and Kentucky, you've got family property that's been around since 1700, 1600. I mean, long time. And so the way I look at it is the system in Kentucky is set up to, one, help get the taxes paid, because that's important. And that's an important, thing that our industry does, to make sure that kids going to school and all these things that, but it also provides every opportunity for these folks that have a significant attachment to the land to be able to keep that property. And so, you look through and you see the payment plan, you see the second redemption, you see all of these things, 11 years, to try to work this out. All of these things to me show a legislative intent when they're developing the statute to create a system which allows again, like I said, for the taxes to be paid, allows for people to pay the taxes to make money, but really tries to push the acquisition of property far to the back burner and to be a last kind of resort. And really only a resort that occurs if the family absolutely can't or has no interest in maintaining the property.
Right. Right. I mean, I'd even venture to say, Randy, that this may be the most, I'll say, fair system that I've heard of. Typically it's very one-sided, where it's very difficult, for a lien holder or an investor to enforce it, or the opposite, where it's so investor friendly, you feel, sympathy toward, sympathy toward the property owner. And it sounds like Kentucky is definitely not where you want to go. If you're an investor looking for the properties, you don't want to go to the lien side. You can maybe go to the master commissioner sale. But it's a very fair process on both. You can make money on the lien side. If you're the property owner, you have many attempts and opportunities to maintain ownership. And so that's pretty unique. I haven't interviewed attorneys in every state, but I'd say of the 20 or so I've interviewed so far, this is unique, which is great.
And I would say too, if you're interested in property acquisition, your point is really well taken. That the master commissioner sale, and you can basically prepare by understanding what the master commissioner appraised it for. So then you go in at 67%. You say, for every property you're interested in, I'm going to bid at least 67%, maybe not more than 70. If I get them, great. Then I've at least got a 30% built-in equity. Mm-hmm. But the problem with that is, the master commissioners are just randomly, and so you got, again, I beat this dead horse, so I apologize. But you got 120 master commissioners that are just setting foreclosure sales. So it's hard unless you have a specific market, unless you say, I'm going to rent to students in Eastern Kentucky University. And so I'm going to go to Richmond and I'm going to buy properties, from the master commissioner there. Or I'm going to go to Morehead State, and I'm going to go to Round County, and I'm going to buy them there. So I'm going to, follow the master commissioner and try to get those properties. So, I think if you have that business plan and you're looking at it and you're saying that's how I want to roll this out, it's possible. I don't know that it's possible based on the way the master commissioners set the sales across 120 counties to do that, because you just run yourself ragged. But if you had a specific market where you're trying to acquire property for a rental business and you know who your rental market is, you could tag a few counties, follow them. And I think you could then end up acquiring a significant amount of property in those limited locations where you have a market.
Right. Well, Randy, this has been enormously educational for me. The previous one was as well on Kentucky, but I'd never heard all the specifics on the enforcement side. And so I want to thank you for me, but also on behalf of our listeners for that knowledge and sharing with us. And I hope we can have you back again soon.
Love to.
All right. I appreciate it. I'm going to hold you to that. Well, thank you again, and we'll talk soon.
All right. Hey, take care.